Hi, thank you everyone, and welcome to Zoom University, a Self-Care Survivor Series. This series is brought to you by NRAPE on Campus, and it's on us, two national nonprofit organizations focusing on ending campus sexual violence. The purpose of Zoom University is to create a virtual community space for students, survivors, and advocates, especially during this time of COVID-19 and social distancing. We wanted to make sure that with respect to the pandemic, resources and information was being shared and students, survivors, and advocates know that they are not alone in this time. We hope that you all are doing well, staying healthy, and that for anyone who has lost a loved one during this ambiguously tough time, that you are in our thoughts and prayers, and our hearts are with you. With that being said, my name is Kinyora Parham. I'm the Executive Director of NRAPE on Campus, and today's webinar, COVID-19 and its effects on Title IX investigations, is a crucial topic for many on and off this call. A couple of weeks ago, we received word that Title IX regulations have been approved by the Office of Management and Budget, aka OMB, and the final regulatory, which is the final regulatory hurdle. And this means the rule can be published at any moment. Yes, that includes a pandemic. I want to give a special thanks to our partners. It's on us for co-creating this series, and our speakers from Equal Rights Advocates and National Women's Law Center for their time, expertise in this matter, of course, whom I'll be introducing momentarily. Before I officially introduce our speakers and provide some reminders, would like to turn it over to my visionary partner for this webinar, Shannon Williams of Equal Rights Advocates.
Thanks so much, Kinyora. You're really the visionary for this webinar, but I appreciate the kind words. I just wanted to give a heads up for organizations that are joining today's call. We'd also like to take this time to invite you to join the Stop Harassment State Network. This network is co-led by Equal Rights Advocates, National Women's Law Center, and Girls for Gender Equity, and really focuses on helping state and national partners replicate groundbreaking and influential policy reforms that are related to sexual violence and income inequality. Currently, we have over 35 organizations representing all parts of the country, and we meet monthly to coordinate policy reform efforts, develop and support on-the-ground organizing efforts, and just share best practices and strategies that can be replicated in all different states. So if your organization is interested in becoming a part of this network, please reach out. I believe the information is going to be sent in an email following this webinar, and I can include that in the chat box as well, but we'd love for your organization to be a part. And just as a note, the network currently right now is only open to organizations. So if you are an individual, you can definitely reach out to me and we can discuss ways that you can engage in this work. But if you are an organization, we would love to have you a part of this network.
Thank you, Shannon. So now I would love to go over just a couple of reminders for you all while you're on this call. And that is that this call is expected to run for about an hour and will be recorded and made available for future reference. So therefore, please feel free to hop off this call to either take a 5-minute breather if you need to take a sip of your tea or coffee or whatever you might be drinking at the moment, or if you need to move forward with your day. I also want you to know that Sylvia Centano, Director of Education and Training of It's On Us, will be managing the chat box, which is located on the right side of your screen. So for those calling in, please feel free to send your questions via the chat box or at our email if you don't want to put that in a public space at info@nrapeoncampus.org. And you can also live tweet us at nrapeoncampus or at It's On Us. So you're more than welcome to keep your cameras on or turn them off throughout the duration of this call. But we just ask that you continue to remain on mute and use the chat box to be in community with one another. Sylvia will help to answer any questions as they come, and if not, towards the end, we'll be sure to send up a follow-up email with questions and answers and other resources that we'll be providing throughout the duration of this call. So now to our conversation, I would like to introduce our guests. So Brenda Adams, her pronouns are she, her, hers, is a senior counsel of education and equity and litigation at Equal Rights Advocates. Brenda leads ERA's education equity work, manages its direct legal services programs, and litigates sexual violence cases. Brenda's work focuses on ensuring survivors of sexual violence maintain access to educational and employment opportunities and receive culturally sensitive and trauma-informed legal services. Brenda's litigation efforts focuses on bringing impactful litigation and seeking programmatic relief that results in structural changes to empowerment or school policies relating to gender-based violence and discrimination. Brenda also consults on local, state, and federal legislation relating to education equity. And Brenda's prior work on behalf of survivors of domestic violence, sexual assault, and child abuse informs her trainings to nonprofit organizations, private law firms, and pro bono attorney volunteers on trauma-informed services and survivor advocacy. Our next speaker is Shwali Patel. Her pronouns are she, her, hers, and she is the Director of Justice for Student Survivors and Senior Counsel at the National Women's Law Center. There, she leads the federal, state, and policy development and advocacy, litigation, and education addressing gender-based harassment in schools, including sexual harassment and sexual assault, and safer school climates. Previously, she was at the U.S. Department of Education's Office for Civil Rights, where she worked on civil rights policy and legal guidance, interpreting Title IX's anti-discrimination protections, including schools' responsibilities in responding to sexual harassment, protections for transgender and non-binary students, and the rights of girls of color. Before joining OCR, Shwali was an administrative judge and investigator at the U.S. Department of Energy, Office of Hearings and Appeals, a special assistant United States attorney in the District of Columbia in the Sex Offense and Domestic Violence Unit, and a law clerk to the Honorable Laura A. Cordero at the Superior Court for the District of Columbia. And prior to law school, Shwali was a community educator at the District of Columbia Racist Christ Center, where she conducted workshops and educational presentations for adults and adolescents on sexual assault, domestic and dating abuse, and sexual harassment, and was a trained hotline counselor and hospital advocate. So with that, now that you got to know just a little bit about our guests, I definitely want to start our conversation. And I want to start with you, Shwali. So with a couple questions I have for you, and starting with the first one, for those on the call and will be able to see this recording later, can you just give us an overview of what Title IX is and why it's important to know?
Sure. And first, I want to say thank you so much, Kenyora, for having us here. This is an important conversation to be having, and especially right now, as you mentioned, because of the changes that we're expecting any day now to the Title IX regulations. So I'm really pleased to be here, and I hope I can be helpful to all of you that are tuning in. So, for those of you who don't know, Title IX it's a very critical law. It's a civil rights law that prohibits sex discrimination in education. And it applies to school districts as well as colleges and universities. And it applies to recipients of federal financial assistance. So almost most colleges and universities have to comply with Title IX, even if they're private institutions, because they receive federal money through federal financial aid. And so Title IX prohibits sex discrimination in a variety of ways in education, so including through admissions, financial aid, scholarships, housing facilities, athletics, and it also protects students and employees from discrimination. And it protects students of all genders. And what we will be focusing on for today's conversation has to do with Title IX's protections against sexual harassment, because it does ensure that schools have published anti-discrimination policies and grievance procedures to address sex-based discrimination, including sexual harassment.
I need to unmute myself. Thank you so much. Can you go a little bit more in depth about what forms of gender-based violence fall under Title IX?
Sure. So there are many forms of gender-based violence, so including violence or harassment that could target students based on their pregnancy, for example, or termination of pregnancy or related medical conditions. It could be based on a student's sexual orientation or gender identity, or forms of dating violence or domestic violence or sex-based stalking, even if it's not rooted in sexual violence. And of course, it also includes sexual harassment as well. And sexual harassment, generally speaking, is conduct of a sexual nature that's unwelcome. It interferes with the student's right to learn, to achieve, or to feel safe and comfortable in schools.
For anyone who's experienced sexual assault, what should they know about their Title IX rights?
Sure. So there is a resource from the National Women's Law Center that I'm going to plug. I want to give a plug for, and I have it with me. It's our toolkit, and this applies for K-12 and institutions of higher education, and I think we're going to provide a link to it. It is available on our website, and it provides an overview of what your rights are if you have been sexually harassed. So there are a few kind of general things that students should know are part of their Title IX rights if they've experienced sexual harassment, including sexual assault. So schools need to have a Title IX coordinator, for example, and that person's name and contact information should be available. And there should also be a policy at the school against sex discrimination, and schools should have published grievance procedures that would apply for sexual harassment. So students and employees can know what would happen if they were to experience sexual harassment or report a complaint. They should know what type of investigative process their school has, whether or not there's a hearing involved, the timelines for the investigation, what it would entail. And when a school is on notice of sexual harassment, they need to investigate to find out if the harassment has created a hostile environment. So essentially, if that sexual harassment has made it harder for you to learn or to feel safe and comfortable in school. And the investigation should be prompt and it should be equitable. And so that means that, the rights to both the complainant and the respondent. So the complainant is a person who's bringing the complaint. The respondent is the person who has been, who the complainant is accusing of harassing them. Their rights should be equitable. So that means if one party is allowed to have witnesses, that the other party should as well. That means that the standard of evidence needs to be equitable, which is preponderance of the evidence, because that puts both parties on equal footing. Schools should also ensure that they provide interim measures. So these are like accommodations or support services to ensure that students feel safe at school, even during the investigation while it's pending. So this can mean academic accommodations, this can be counseling, stay away orders, changes in housing, it could be a number of things. And schools should still be conducting their investigation whether or not there is a pending law enforcement investigation. And I think this point is really critical to emphasize, just because of how Title IX has been talked about, especially in the media, and given the changes that we're expecting to see by the Department of Education. Title IX is not a criminal law. It should not and does not have the same requirements that we see in the criminal process. It is a civil rights law. It requires that there be certain civil rights protections for students, and that includes ensuring that there is an equitable process. So it's just very important to keep that in mind, that Title IX, again, is not a criminal law, and it is a civil rights law.
Absolutely. Thank you so much. Brenda, to get your insight on this, especially now during this time, the COVID pandemic, to ensure that Title IX cases are not falling behind the cracks, what should schools be doing?
Yeah, thank you, Kenyora. And I also just want to start by also thanking you all for inviting me to participate in this webinar, and to all of you attending for inviting us into your homes on this day and during this very difficult time. I'm really honored to be here. This is a really big issue and an important issue. Title IX and the protections for students are always important, and during this particular time, I think they're even more important and they're more at risk. And so that's what we're going to talk about today. I want to go through a few of the tips that we've come up with. We've at ERA provided and created a guide, which is guidance for both schools and students for how people should be proceeding with their Title IX cases during this COVID crisis. And I think Sylvia is going to provide that link in the chat box. But I'm going to go through some highlights of that guide right now. And so really, like starting at the basics, I know some of this is going to sound really basic, but all of you out there who have been involved in Title IX cases, you know, schools don't often know even the basics. So that's where we're going to start. So the basics are, they need to establish remote work plans. And I'm talking about what schools should do, but I'm hoping that all of the students and survivors out there listening right now are paying attention to this piece, because these are things that I think you should all be advocating for on your own behalf or on behalf of your friends and colleagues. So they need to make a remote work plan. What I mean by that is that the Title IX does not go on hold just because we have a pandemic. People have needs and people have concerns, and they need to be addressed. And some of those, as we're going to talk about, are even increased during this period because of the remote learning situation. So the first sort of tip is that schools need to establish a remote work plan. And if they haven't done that already, 4 weeks into this process, that's concerning. But if they haven't, they need to do it now. So what I mean is, you out there, school administrators, need to assume that this is your new normal and proceed accordingly. And we have some very specific factors that you should all consider that I'm not going to go into in detail, but you need to think through these issues and create a remote work plan that supports the continued operation and responsibilities and services that the Title IX office is obligated to provide. The second major thing is avoid delays, obviously. As I said, the COVID situation does not change students' fundamental right to a prompt and equitable resolution of sexual misconduct claims. And so while, of course, we understand that there is likely to be some delay, we've all been delayed by probably a few weeks in our lives and our work, and we understand that. But that should really be the extent of it. This should not be an excuse to or justification for prolonged delays in the process. And I think, as we all know, and especially survivors know, sitting with the trauma and uncertainty throughout the Title IX case can really prevent people from moving on, finding closure. And the ways that schools handle these cases, if they're mishandled, can cause even further trauma to people. So that's really important. Another thing that's really important, Kenyora, is remote reporting. Obviously, students are in a different situation. They're not physically on campus. They don't have the opportunity to sit down with their coach and have a heart-to-heart and disclose something like this, or with their counselor, or someone that they trust at school. And so the schools need to really make sure that students understand how can they report, what are the various ways and methods of reporting in this remote situation. And on that, I want to make a point, which is, I feel like some people think that remote learning means that reporting won't be necessary. And I think probably most of the people on this call know that that's not true. We often see an uptick in reporting, especially of sexual assault, when students have time to go back home or have some time and space from the assault, and things tend to come to the surface, and that's when we see an increase in reports. So we see an increase in calls to us for services that happen during traditional winter break or summer break and spring break and things like that. This is no different. So I think we can expect to see an uptick in reporting, and schools should be prepared for that. In addition, there are new things that students are going to be reporting now, and we'll talk about that a little bit more. But there's new forms of harassment and new openings for people to harass other students with this remote learning situation. And so schools need to be prepared for that. And of course, need to be, as Shivali pointed out, continuing to do all the things that they're supposed to do. Provide supportive measures, which may be more difficult to access now. And maybe there are more increased needs for supportive services that students have because of everything that's going on. Maybe the existing interim measures that have been taken are not adequate. no longer adequate to address the student's need, and that is the legal requirement. The measures that a school institutes need to be effective. That's basically the standard. If they're no longer effective because you're now, learning remotely from your home, then I would encourage you to contact your Title IX office and ask for whatever it is that you feel that you need. And the last thing I'll say, Kenora, and we can talk a little bit more in detail about this in a minute, but there's no one size fits all here. And we are encouraging schools to be flexible, but also prompt, right? So there are appropriate cases where a school should be flexible about timelines. There are, for example, survivors who have not disclosed to their family what's going on. And to conduct a hearing from their bedroom when their parents are in the next room and can hear everything may not be appropriate for them. Or that may just be that the student has such an increased trauma from this global pandemic on top of everything else that now is not a good time for them to conduct an interview on their assault. Or there may be disability issues or tech access issues that prevent a student from participating. So these are all things that schools should take into consideration, while at the same time ensuring that no one is taking advantage of the situation and pushing for continuances or extensions simply to abuse the fact that this crisis is going on.
Absolutely. And, while the schools have these obligations to fulfill, I'm certain that there are students on this call who are like, but what are my rights as a student, and how do I make sure that my school is fulfilling their obligations under this Title IX process?
Absolutely. So first of all, I wanted to touch back on something that Shivali mentioned, which was you are entitled to a prompt and equitable resolution of your case, okay? Equitable does not mean equal. So that's why it doesn't say equal. Equitable means basically fair. It's about leveling the playing field. So if you think about it like a basketball game or something, and you have two players, one is 6 feet tall and the other one is 5 feet tall, they're if they both stand at the foul line and shoot, that's equal, right? But it's not necessarily equitable. So you might want to move the 5-foot person up a couple feet to make it fair so that it's equitable. And that's an important distinction, because I think you will find, if you haven't already, that schools are very committed to equalizing everything. And we all on this call know that things are not equal to start with. You're not all starting on equal footing with your respondents, and you know that for various reasons, and some of you less so than others. And so one thing I just want to promote you all to do is to push for that equity and try to advocate for the policies or measures or practices, whatever it is that you feel in your heart would be fair to you, to advocate for those, because there's no rule book that says X is correct and Y is not. So I want to encourage you all to do that. I also want to make sure all of you know that we at ERA, I know there's a lot of folks from California on the call, we have a program which is called our Enough program, where we provide direct representation, lawyers to represent students in campus cases. And I know Sylvia is going to provide the link for that information. Those are free legal services. Some are ERA attorneys, some are attorneys who are members of our pro bono network that we have developed and that we personally train on trauma-informed practices and Title IX. And so I would encourage you all, if you're interested, to reach out to try to get an attorney in your case who can advocate on your behalf. And if that's not an option, that's okay. You don't need to have an attorney, but it's just an option for you. And then we, as I said, I would encourage you to look at the guide that Sylvia is sharing, because all of these tips that we have for schools are things that we hope that you all will advocate for. And so you can send an email to your Title IX coordinator and say, hey, I haven't heard from you at all, and I have an ongoing case. I need you to tell me exactly what the timeline is. If it's been delayed, I am entitled to know. And you do have the right to know of any delays in your case or the timeline. That's a piece of, an important piece of the policies. So those are the types of things that I would suggest for students. And then there's also a letter that we have a link to, which was a letter that NWLC and ERA and others, Know Your Nine, signed on to, encouraging school administrators to take certain steps to protect students during this time. And you can always copy that letter and send that off yourself as well.
Absolutely. So, let's say I'm a student and I have a current Title IX case happening right now. What types of accommodations should I be receiving right now?
So that really depends on what you need. So if what you need is, for example, maybe you had a no contact order with the respondent in your case and they weren't supposed to contact you via phone, or they weren't supposed to be in the same room as you. But now that situation has changed, and now you realize that they're actually on a remote classroom with you now. Now you may need a different type of order. Maybe you need to ask your school to modify that no contact order to say, in addition, they're not to contact you, they're not to share their screen with you or whatever, communicate with you via chat. We actually, in that guide that I mentioned, have an entire section that relates to remote learning and very specific and particular advice on what schools and students can do to protect each other from harassment. And so I would recommend looking at that. But it may be that you need an extension on an assignment, or you need, you may actually need some technical assistance. Maybe you need a laptop. Maybe you want to participate in your case and you want it to go forward right away, but you don't have the actual equipment that you need to do that. That's a request you can make. So I encourage you all to just open up your minds and not be afraid to ask for whatever it is that you need. Sure, they can say no, but that's the very worst thing that can happen. And as a litigator, I know some of you are thinking, well, what about suing my school? Is that an option for me? All of these little points during your campus case become facts that could be useful in a lawsuit if that was a direction you wanted to go in the future. So generally speaking, if you have a request to make, put it in writing, make sure it is in writing. It doesn't need to be formal. It can just be an email to your Title IX coordinator that says, I need X, Y, Z, and here's why I need those things. But if they later deny that, then subsequently, if you choose in the future to, file litigation against your school or take some other legal action against them, you will have that evidence that you made those requests and that they denied them unreasonably. They shouldn't be denying them if it doesn't prejudice anybody to give it to you. So if it's not going to hurt anyone else, there's no reason to deny you that benefit.
Absolutely. And you did talk about litigation that one may take against their school, but before we get into that, you did mention no contact orders. Now, are there other examples of court orders like that schools and all parties involved in a Title IX case should be adhering to? And what does that look like?
Yes, absolutely. So let me clarify. When I say no contact order, I mean really just a piece of paper that a school issues that says one party is not to contact the other party. I'm going to pause here to say that it is important in my view, and I'm sure Shivali shares this opinion, that if you are the complainant in a case, that no contact order should be one way. We call it a unilateral no contact order. You have done nothing wrong. No one has ever alleged that you did anything wrong. So there's no reason why you are not free to contact whomever you please. Now, of course, you're not likely to want to contact the respondent, but the point is that violation of a no contact order can subject people to sanctions. So there's no reason for you to be subjected to an order that could subject you to sanctions for no reason. So I would encourage you to advocate that those orders be made unilateral. But basically what those orders are, that's just the school saying one student shouldn't contact the other, and if they do, they may have some discipline. A court order is a very different thing, and that is something you can apply for. That is some of the work that I used to do when I represented domestic violence and sexual assault survivors. There are various types, and it depends on your state in terms of what your options are, but typically you will have the option to apply for a restraining order. That's a civil case. where you essentially establish to the court that you have been the victim of some type of abuse, however your state defines abuse. And if the court finds that to be true, they will issue a restraining order that orders the respondent in the case not to contact you, come near you, and you can get other various benefits as well. Like if you have children with them, you might be able to get some custody orders and things like that. But for our purposes, it's really about protection. And the benefit to having a court order versus a school issued order is that it is enforceable by the police. The police are required to enforce a civil restraining order. So if someone were to violate it, you could contact the police and they would come out and it's a misdemeanor to do that and the respondent could be arrested. Whereas on campus, what we see pretty typically is if there's a violation, there's not going to be an arrest made, for example. It might become part of the investigation where the investigator will now look into this, alleged violation of the no contact order. And maybe the respondent will be subject to a sanction, but usually you'll see like a warning or something. So it's just not as strong. If you have a court issued restraining order and your school is acting like they don't need to enforce it, you can use the campus police for that purpose, because again, campus police, if they are law enforcement and not just sort of the like rent-a-cop type of person, security personnel, then they are obligated to enforce it. So you can also use that potentially as leverage with your school to say, hey, this person can't be in my class, for example. You need to move him out of my class because I have a restraining order and they're not allowed to be within 50 feet of me or whatever.
Thank you, Brenda. Shirali, we'll definitely bring you back into the conversation, but I really want for Brenda to dive a little bit deeper in this process of reporting to the Department of Education. Let's say, if a student is, trying to receive communication from their school about their current Title IX case, but there's a failure or a lack of communication from the school, there's a delay in the Title IX investigation overall. Or let's even say in some cases that I've come across, there are students who try to engage with their Title IX coordinator, but yet they seem to be siding with their perpetrator. So Brenda, can you dive a little deep into how a student would proceed to file a complaint with the Department of Education?
Sure. Filing a complaint with the DOE is really pretty simple, and most California has an Office for Civil Rights. You can do that federally. You don't need a lawyer to do it. We can provide the link for the OCR's website. And in fact, one of the requirements that Shirali was referencing earlier is that schools do provide that information on their website somewhere where it's easily found. So you should be able to find that. If you can't, your school probably isn't doing what they're supposed to do, but we wouldn't be shocked to see that. But so basically it's an administrative law complaint. So you're just saying, you provide the factual information about what happened, the sort of timeline of events, where you feel like the school didn't comply with what it's supposed to do. And then you file it, and it usually takes some time, some months, for the situation to be investigated. And then sometimes the OCR will respond if they find that there were some problems. I typically see that they will then reach out to the university to try to reach some type of agreement. We think you did X, Y, Z wrong. We think you need better training. We think you need changes to your policy. We think you need to redo this investigation. They might say that. And then typically the school will reach some type of resolution agreement with the OCR on that. In a more extreme case where you see like really egregious violations, you might see a fine instituted by the OCR against the school. I'm going to tell you that I would be shocked if that happened in this administration right now, which leads me to my point, which is whether or not to file a complaint with the OCR is entirely up to you. I would encourage you to think about what your goals are. If your goal is that you want your Title IX coordinator to respond to you or to do something right now in your case that they're supposed to be doing that they're not doing, I wouldn't necessarily recommend filing an OCR complaint. I don't think that's the fastest and most efficient way to get what you want. I would recommend probably contacting an attorney. And again, you know, we have folks who can just give you advice on the phone and you can do it yourself, and that's fine. But I think sending something in writing that sort of tells the school, puts them on notice, I know what my rights are. Here's where I know where those things come from. Here's the regulation, here's the case law, here's where that stuff all comes from, and you're not complying with it. And here are my specific requests. And if you don't give me my, you know, if you don't grant my request, me and or my lawyer, you know, will be looking into legal action. That's what we call kind of a demand letter type thing. I think that could be an effective way of getting their attention. I think what we find is that schools, the reason you sometimes see or feel like schools are bending over backwards to accommodate respondents is because respondents are the ones that sue schools. So schools spend a lot of money. They don't actually typically side emotionally, morally, you know, ethically with the respondents. I find that when I talk with administrators one-on-one, they're very sympathetic to the issues that our clients are facing. And at the same time, they are on the receiving end of massive amounts of lawsuits, and they're encouraged to avoid those lawsuits. And so if they think that by bending over backwards for the respondent won't sue them, that may be what you're seeing. So being a person who would potentially be willing to sue them and expressing that could help convince your school administrator to like level the playing field and give you what you are needing.
Absolutely. Thank you, Brenda. Shwali, to bring you back into the conversation, I'd love it if you would provide folks who are not familiar simply with the status of Title IX regulations, and going back to what we said earlier about this impending rule drop by Betsy DeVos and the Department of Education. Can you provide us with like a rundown of what the implications of the rule could mean for students?
Yes, of course. So it's really important to kind of understand why these regulations are important. So as Brenda was talking about the OCR process, so at the Department of Education, so what OCR would be relying on are these new Title IX rules to guide how they're going to investigate a complaint that comes before them alleging a Title IX violation. And OCR also has had guidance documents. So, you know, you may have heard about like the Dear Colleague letters, for example. Those also have guided OCR investigators when they receive complaints alleging, you know, any sort of civil rights violation, including Title IX. And so we, you know, you may have followed some of the resources that any of our organizations have sent out about these proposed rules. We're extremely concerned about them. Ultimately, we strongly believe that they would make campuses, actually all schools, school districts, K-12 schools as well, less safe for students, and they would hold schools, you know, less responsible for not responding adequately to sexual harassment. And I mean, this is just kind of another way on top of many other ways that Betsy DeVos has attempted to undermine Title IX protections for students. And this started in 2017. In the beginning of the Trump administration, when Betsy DeVos rescinded critical guidance from 2011 and 2014 and replaced it with a 2017 Q&A question answers document, which rolled back a lot of protections for student survivors of sexual harassment, and including sexual assault. So, so what these proposed rules would do, they would change the Title IX regulations, and they would do a number of things to weaken protections against sexual harassment. So one thing they would do is they would allow schools in many instances to ignore known incidents, reports of sexual harassment if it occurred outside of an education program activity. So this includes a lot of off-campus sexual violence, thinking of sexual assaults that might occur at an off-campus fraternity party, for example. It would also, it could exclude a lot of online harassment as well if it occurs outside of an education program activity, despite the impact on a student's education, despite the fact that that student might be in the same, that survivor might be sharing a class with their rapist, with the perpetrator, or might even be taught by someone who harassed them or assaulted them. And so, we know it doesn't really matter the location of the assault for survivors' education to be impacted and harmed. And so, that is one significant concern we have with these proposed rules is the way they were proposed is that they would actually require schools to dismiss those complaints. We've heard reporting a few months ago, this was what was reported in the New York Times article. We don't know if this will happen, that because of the pushback to that forced dismissal, that the department might change it and just say schools are allowed to dismiss it. They wouldn't have to, but even still, to give them that option is concerning, because they should still be investigating those type of complaints. The other is that the proposed rules would only hold schools accountable if a small subset of employees were aware of sexual harassment and didn't do anything about it. So, for example, if a student survivor has reported to their coach that they've been sexually assaulted, or the coach knew about that they were experiencing sexual assault from another employee and didn't do anything, the school would not be accountable. There would only be held accountable if the Title IX coordinator was aware of the report, or an official with authority to institute corrective measures, which they haven't really defined, but it could be someone like a dean, someone who many students might not have a relationship with or might not feel comfortable enough to approach. And for K-12 schools, teachers would count as these types of employees that would have that responsibility to do something in support, only if a student is reporting student-on-student sexual abuse, not if another employee sexually abused them and they told the teacher. If that teacher ignored it, the school would be off the hook for not doing anything. There are a number of other changes, including changing the definition of hostile environment so that a student would have to report more severe forms of sexual harassment, including sexual assault, before a school would have to investigate. And then, assuming that a survivor does actually get through those hurdles and a school does begin an investigation or a hearing, under these proposed rules, the process that they would use would be extremely inequitable and could be re-traumatizing. And so there has been a lot of reporting about direct live cross-examination, which is one piece of that we have strong concerns about. And so what DeVos would essentially do is allow or require schools to provide for direct live cross-examination in institutions of higher education. This is very concerning. We know that this could deter reporting if someone knows that by reporting that they've been harassed or assaulted, they might have to be questioned by an attorney that their harasser hired, or even a friend of theirs. It doesn't really limit who would be able to do the questioning. And witnesses would also have to be subjected to live cross-examination as well. And so we have concerns that witnesses might be more reluctant to participate in the process, even if they have critical information for the investigation, because they wouldn't want to be cross-examined. It would also require essentially force schools into using a more burdensome standard of evidence that harms complainants, that would provide, that would make it inequitable, that would essentially, make it more burdensome to be able to kind of prove or to show that they've experienced harassment. So to use the standard called clear and convincing evidence versus preponderance of the evidence, and this would just make it harder to show that a survivor has experienced harassment. And there are a number of other things. Sorry, I could go on, and the list is very long, but we have resources available on our website where we've kind of broken down all the proposed changes. It's nwlc.org/respectstudents. And I know there's also handsoff9.org. So there are different resources available online that provides a very some more thorough and some more brief explanations of these rules. But it's important to know that it's not just our organizations or survivor advocates or students who have kind of spoken up against these rules. The Department of Education received over 120,000 comments. So a lot of people have been very invested in ensuring that these proposed rules, because of how harmful they are, do not move forward. And this includes civil rights organizations that have pushed back. A lot of schools and institutions have pushed back, and students and families and survivor advocates. So, if Betsy DeVos were to continue to move forward on these extremely flawed and harmful rules, it kind of makes you wonder, who are they really responding to, which, I believe are the respondents and men's rights advocates and sexist extremists. And so, we have concerns about that, and I know some of our organizations are planning to continue the fight if when these rules come out. As to timeline, we don't know when the final rules will be out. There has been reporting, as Kinyora stated in the beginning of this presentation, that OIRA, or the Office of Information Regulatory Affairs within OMB, has completed their review of the rules. That's kind of like one of the last steps before a final rule comes out. Now it's back with the Department of Education, and they are now have to take into consideration OIRA's review, whatever came out of it, and then they issued the final rules. And the last that we heard, just based on what's been reported, is that it, again, could come out any day now. And so I would, if you want to follow what we're doing, follow what happens with these rules, our websites will be updated with information, and I'm sure you're going to get information from EROC about that once they drop.
Absolutely, absolutely. So I see that we do have a couple questions from our attendees, and just for the sake of time, I would love for us to kind of dive a little deeper into that. And so I see a question from Kimberly Simon, and I want to say this question maybe for Brenda or Shwali, whoever wants to take this on, but can you talk about how you're getting around the challenge in issuing unilateral orders, especially with the new proposed regs? We're getting pushback and doing a preemptive NCO. After a finding, of course, there's no problem. Can you talk a little bit more about that?
Right. Yeah, thank you. Yes. Thank you, Kimberly, for that question. And you're right. And I shouldn't behave as though it's a simple thing to obtain, especially now with the new Title IX regulations that are coming down every day, which have a provision in them that basically require that the measures are provided equally to both parties, which again is utterly absurd, given that the standard is equitable, and that, again, a respondent would have no need for a no contact order because they were not the subject of harassment. So obviously arguing that is helpful, but it's very problematic. I think citing to the previous and still existing guidance that states the standard as equitable and not equal can be helpful. Also, we have articulated it in retaliatory terms. So Title IX prohibits retaliation. We didn't really explain that, but I think we all know that Title IX, or hopefully we know that Title IX prohibits retaliation. And when you think about it that way, when you articulate it that way, a survivor who reports an assault, who then has an NCO issued against them, that violation of which could result in discipline, that seems pretty retaliatory, right? So I would certainly argue that. And then this is a little bit of a different topic, but what we're doing here in California is that we are working on a bill to protect survivors from invasive and traumatic procedures. And in that bill, we've included a provision that prohibits the issuance of a mutual no contact order if there are no allegations against the reporting party. So yes, is this potentially going to prompt respondents to make allegations that are untrue? Potentially. But at the very least, where none exists, there's zero reason to have a mutual order. And so I think if you have the ability in your state to potentially get involved in some legislative work, I would highly recommend that. because I think that the states are at this point survivors' best bet to fight against these horrible federal regulations that are coming out.
Thank you so much, Brenda. We have another question from our attendees from Lisa Connolly. They asked, is there anything that students can do if professors aren't being flexible or accommodating with online learning, interim measures, extensions, alternative assignments, etc., that were previously implemented in the classroom, or is the discretion completely up to each faculty member? And that can—
This one's tough. Yeah, Shivali, chime in if you want, please. This one is difficult because I think it varies a lot school by school. So if you have, and typically this is the result of teacher union contracts that establish very clear parameters around what is their, like what is the sphere of their control versus what can the administration control, and we're all for unions. So that is not a diss on unions at all, simply just the fact is that those types of contracts sometimes lend themselves not well to flexibility in various situations like that. That all being said, you will often see, if you're a student and you make a request directly to a professor, you may get some pushback, and there's a lot of reasons behind that. Some of it is just flat out ignorance and not understanding what your issue is or why you need it. Maybe they don't even know about your report. Maybe they have no understanding of trauma-informed, practices, or maybe they're just really old school and they don't think anyone should get any extensions on anything. So my first recommendation would be to absolutely go through your Title IX office. If you are here in California and you have the benefit of going to the UC or CSU system, they have specific offices that are designated for basically care professionals, so counselors and people like that, whose job it is to advocate for those exact types of things on your behalf. And it will probably carry much more weight coming from that office than it would be coming directly from you. And then they can sort of assert their independent power and authority. They have responsibilities, legal responsibilities, not just under Title IX. And we're not going to go anywhere deep here, but remember, for the many of you who suffer PTSD or other mental health issues, you have rights under the Americans with Disabilities Act, and you have the right to request accommodations, and your school is obligated to provide whatever accommodations are necessary for you. So that's something I would also pursue. You may at your school have a different office apart from Title IX that is responsible for those types of requests. So you may need to go to both places, or you may need to ask them to coordinate with each other. But I think having the requests come from them rather than you will be more effective. And then the last thing I'll say about it is, this is hard because for you it's very obvious why you need it, but it's not obvious to other people. And so if you can be really clear about tying the accommodation that you're requesting to your situation, why is it that you need this accommodation? And I'll give you an example quickly from a law school, something that recently came to us through someone there. A student had requested that they be informed in advance of the criminal procedure final or whatever it was they were going to be taking, whether a question on rape was going to be on the exam, because they had recently been raped, and they wanted to know ahead of time simply so they could prepare themselves. And at first the professor completely fought that and was like, you want special permission to know what the questions are going to be in advance, and blah, 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 blah. Well, the care advocate got involved, and from there it went much better. And the professor, I think, ended up just telling everyone equally, all the students, whether or not a question about rape would be on the exam. And that's, there's no harm there in doing that. Nobody is suffering. And that student felt a lot better going into that exam, knowing what to expect. And so, part of it is understanding that these people, these teachers, they don't all understand. And unfortunately, they need to have it explained to them very explicitly why it is that this matters to you. Why do you need to know that question before the test? And even though it's very obvious to probably everyone on this call, it's just not obvious to other people.
Absolutely.
Also, sorry, just to add to that, we also still have the 2001 sexual harassment guidance from the Department of Education, and that has a lot of great language about this, and it does talk about interim measures and accommodations that schools should be providing. during the pendency of an investigation, then of course, even after there is some resolution of the complaints. I think that's an important source. There's also Clery, which I know we're not talking about as much, but that also, Clery is another law that impacts institutions of higher education, and it does require that schools have written policies about certain types of interim measures or accommodations, I think academic accommodations as well, when students bring complaints of sexual violence. So it might be in the policies as a sort, like there should be some policy around it if, you know, the school does provide for that. So that might be another source. And because we're close to the end, I wanted to give a plug for our legal network for gender equity for anyone who is looking for legal assistance. The National Women's Law Center does have a legal network for gender equity where we can, you know, could provide the names of attorneys who have agreed to be part of this legal network from all over the country to hopefully be able to, they can't, it's not committed until you reach out to them, but to take on cases of sex discrimination, including sexual harassment in school. So I think we'll be providing that link, but there is an intake process and more information on our website about that.
Absolutely. Thank you both so much. Before we close out, I just want to recognize just the amount of information that was very informative that you both have shared in terms of your expertise to our attendees. You know, I also want to recognize that, you know, we are in this kind of strange, weird space of like quarantine and social distancing. And, you know, I just want to make sure that we have time to just, you know, close out on a high note in terms of what we're grateful for during this time. Because I know for our callers, our attendees on this call, you know, they may be just like, you know, thinking about their Title IX case or a friend of theirs, or maybe your students of theirs. And I just want to make sure that we take a moment to like, just talk about like what we're grateful for. So maybe we can end the call with that. And I'd also love for those who are on the call in the chat room, if you want to share what you're grateful for during this very overwhelming and daunting period, we definitely encourage you to do that. And I can start. And I will say that I'm actually grateful for the two of you because I am not a legal expert by any means. I am not an attorney. And it's partners like both of you that, you know, really that I rely on, that we rely on to make sure that what we're doing is, you know, in the best interest of survivors, and that the information that we're receiving is coming from the experts like yourselves. So that's what I'm grateful for, the both of you.
Thank you, Kinyora. I'm really glad that we're closing with gratitude, because I find it to be a very important piece of my own survival through doing all of this work, and my resiliency in this, and especially just right now in this time. And I am feeling extremely grateful for the fact that I have a job that I can do remotely, and that allows me to feel like I am not helpless, that allows me to do this incredible work with all of you incredible people. I am inspired to no end daily by my clients, first and foremost. Their strength and resiliency and power and stories and voices are what push me every single day to deal with the fact that I have an 8-year-old who I'm homeschooling and also working. I get through those moments because I see what my clients are able to get through on a daily basis, and I'm able to push through. So I'm very, very grateful to be able to do this work.
I am grateful for all those things, and also for the grace that we've shown each other and ourselves during this extremely difficult and unprecedented time, and for the patience that we're showing ourselves as we grapple with, you know, kind of dealing with this crisis and how it's impacting us in different ways, and balancing a lot while still, you know, pushing through and doing the important work that we're doing, and showing up in ways that we can show up.
Absolutely, absolutely. Well, thank you both for sharing your gratitude. I want to continue to encourage our attendees to share their gratitude as well. And as you do that, I just simply want to give a special thank you to both Brenda and Shwali from Equal Rights Advocates and National Women's Law Center, respectfully, for their time, your expertise, and of course, your presence during this moment. Additionally, I want to thank Shannon Williams of Equal Rights Advocates and Sylvia Santino from It's On Us for their planning and execution of this series. I really couldn't have done this without you. As earlier I stated, this call has been recorded and we'll be sharing this with you all. But I also would be remiss if I did not plug our webinar that's happening tomorrow. It's called, and please excuse my French, but it is called I Feel Like Shit and Social Distancing Isn't Helping. It'll be at 5:00 p.m. Eastern Standard Time. So if you haven't registered for that yet, I highly encourage you all to do so. You can do that at bit.ly/SAM20. We'll put this in the chat box for you to also see, and you can register through that. We'll be in community with 3 amazing leaders from various professional and personal backgrounds that will simply be having a conversation about what it means to navigate through this ambiguous time of social distancing, whether it's emotionally, mentally, or physically. So we definitely encourage you all to join us tomorrow. So please be on the lookout for the follow-up email, especially from us with regards to any questions that you have shared with us in the chat box. And in the meantime, we hope that you learned so much from this webinar. And just please note, the number one thing I want you guys all to walk away with is that you're not alone in this, and we're here to support you and assist you on your journey. So thank you, everyone, and stay safe and be well. Bye.